Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. And now, with any further ado, I would love to introduce our speakers for the day. We have first, going alphabetically by their first names, I have Judge Allan Goodman. Judge Goodman retired from the bench in 2019 after a distinguished 24 years of judicial service, including 20 years as a judge of the Los Angeles Superior Court and 4 years as an Associate Justice Pro Tem of the California Court of Appeals, 2nd Appellate District. Prior to his service on the bench, he was a lawyer in private practice, advising businesses and handling litigation matters in state and federal courts, and served as a deputy attorney general for the California Department of Justice, where he argued 3 cases before the United States Supreme Court. Judge Goodman has extensive appellate writ experience as a lawyer, Superior Court judge, and Associate Justice Pro Tem. Thanks so much for joining us today, Judge Goodman. Next up, we have Andrea Figler Ventura. Andrea has served as a senior appellate court attorney analyzing writ petitions for the 2nd District Court of Appeal for the past 4 years. Prior to this position, Ms. Ventura represented California state entities in appellate matters, trials, law and motion practice, as well as administrative writ petitions as a deputy attorney general for approximately 7 years. She has worked as an associate attorney for DICMA and was on the California Women Lawyers Board of Governors. Ms. Ventura clerked for the United States District Court for the Central District of California directly after graduating magna cum laude from Southwestern Law School, where she earned scholarships and a position on the Southwestern Law Review. Thanks so much for joining us. And finally, we have Justice Thomas Willhite Jr., who retired in February 2023 after a judicial career of more than 30 years, having served on the former Los Angeles Municipal Court, the Los Angeles Superior Court, and the California Court of Appeal. As a judge in the LA Superior Court, besides serving several criminal law assignments, including long cause criminal trials with a high security courtroom, Justice Willhite presided over a fast track civil trial court for 5 years. And in 2005, having been rated exceptionally well qualified by the California State Bar J&E Commission and the LA County Bar Association, Justice Willhite was appointed as an Associate Justice to the California Court of Appeal, 2nd Appellate District, Division 4, where he served until 2023. He has authored more than 2,000 opinions on many diverse areas of law, including appellate writ procedure. Thanks so much for joining us today, Justice Willhite. All right, I will hand it over to you to begin the program. Again, everybody, if you have any questions, please submit them through the Q&A. You can grab the handout materials from the link in the chat section. And if you have any technical issues or questions throughout the program, feel free to put it in that Q&A section.
Well, thank you, Katie. Thank you for that introduction. And welcome to all of you. Thank you for joining us here today. We envision this presentation as kind of an introduction to appellate writ practice for civil trial litigators. Obviously, we can't cover things in great detail, but what we want to do is hit some of the highlights. We've prepared written materials as well that I think are fairly complete. And we've also, as you can see here on the slide, you need not write down these authorities at this time. We've got them in the written materials, but we've also tried to provide the rules of court and secondary materials that can help you with some of these topics when you come upon them in practice. The way we're going to divide this is I'm going to speak first. I'm going to talk about the technical procedural requirements of appellate writ review. Then my colleague, Judge Goodman, is going to talk about some of the orders you will see from the Court of Appeal and how the trial court handles what happens in appellate writ practice. And finally, our colleague, Andrea Ventura, is going to provide some really helpful practical advice on how writs are evaluated and assigned, and some of the important things you should know to maximize your chance of success. So let's begin. We've got a lot to cover here. The first thing I want to do is give kind of a reality check, which is the following, that the chances of receiving appellate writ review overall are extremely rare. 90% of extraordinary writ petitions are denied summarily. They're called extraordinary writ petitions because it's extraordinary relief. You're trying to bump to the head of the line of the other things that the Court of Appeal has to do, namely primarily appeals. And so generally speaking, absent certain requirements, the writ petitions are not successful. But those 10% that are can be very, very important for your client. Generally speaking, appellate writs are divided into two general categories. The first are what are called common law writs. They are called common law writs because a specific statute does not authorize them to review a particular ruling by the Superior Court. I've got a list here on the slide of the most important common law writs. Really, the two that we're going to worry about here, talk about, are mandate and prohibition. Certiorari is a writ that you probably know from Supreme Court review. I mention it only to be complete because it is a type of common law writ, but it generally doesn't come into play when we're talking about reviewing trial court rulings pre-trial, which is what we're going to be reviewing with extraordinary common law writs. Writ of mandate is the most common writ. It's used to correct an abuse of discretion for our purposes by the trial court or to compel the trial court to engage in a ministerial act. The second fairly common writ is prohibition. It's used to prohibit the Superior Court from carrying out a threatened act that is in excess of its jurisdiction. Sometimes you'll be petitioning for writ of mandate, or in the alternative, writ of prohibition, to either have the trial court do something or prevent it from doing something. Those are the major common law writs. The second general category is called statutory writs. And they're called statutory writs not because they're in substance different from mandate or prohibition, but because they're authorized by a specific statute to obtain review of the specific type of ruling at issue. The most common or most well-known probably is the writ review that's available for the denial of summary judgment or the grant or denial of summary adjudication. That is a type of statutory writ that we'll talk about. The reason it's important to recognize whether your writ that you're seeking is a common law writ or a statutory writ is that the filing deadlines for statutory writs are much, much shorter, and they're jurisdictional. Also, for some rulings, writ review, the statutory writ is the only available method. In appendices A and B in our written materials, we've listed typical rulings that are challenged by common law writs and also by statutory writs with the applicable timeframes. We'll talk a little bit about this in a moment, but it's a very handy reference for you when you're seeking to determine whether the ruling of the trial court you want to challenge is a common law writ or a statutory writ. Let me talk briefly about who the parties are in a petition writ proceeding. The first, for our purposes, is the petitioner. Generally speaking, that's the person or the party that lost in the trial court. The second party is the respondent. For our purposes, it's almost always going to be the Superior Court for the state of California, for the county in which the judge who made the ruling sits. The third party is the real party in interest. Generally speaking, that's the party that prevailed on the ruling in the Superior Court. Technically speaking, as I put in the slide here, the petitioner and the real party in interest don't necessarily have to be parties to the case if they have a beneficial interest in the case or in the ruling. Having said that, I say that just to be complete. For our purposes, I think we're always going to be talking about the loser in the trial court and the winner in the trial court. Two important points. With respect to the respondent court, as I think Judge Goodman will talk about, is really just a nominal party. Doesn't participate in the writ proceeding per se. The real party in interest is actually the party that will be opposing or responding to the writ when that's required. So those are the parties: petitioner, respondent court, and real party in interest. Okay, general requirements of writ review. There are two pretty rigid requirements for writ review that you need to be aware of. First of all, you have to demonstrate that there is no adequate remedy at law for your client with respect to the ruling that you're challenging. And secondly, you're going to have to demonstrate that there will be irreparable harm if writ review isn't granted. I've cited a case here that comes up a lot. It's in our materials, the Omaha indemnity case. These two elements in practice tend to blend together when you're pleading them and when you're arguing them. But I want to be clear that you really do need to plead them as separate requirements, because the appellate court does look for a showing of no adequate remedy at law and irreparable harm. Let me talk about what we mean by inadequate remedy at law. Generally speaking, you got to show that an appeal is not an adequate remedy based on the circumstances that apply to the ruling that you're challenging. And for my purposes, I generally divide them into two separate categories. One is what I call general policy circumstances. Appeal may not be an adequate remedy at law if, for instance, as listed on the slide, the issue was of widespread importance, or perhaps the issue is a novel constitutional question, or perhaps the issue will resolve conflicting trial court interpretations. If these circumstances exist, that's something that you should plead to show that an adequate remedy at law is not present. In the alternative, or in conjunction with that, there are case-specific circumstances that you can plead to show that there's no adequate remedy at law. As an example, that the trial court's order is both wrong, clearly wrong, and will substantially prejudice the petitioner's case, or that the ruling has deprived or will deprive the petitioner of the ability to present fully a particular cause of action. Or in some circumstances, fairly rare, but if it would be required to post a bond for appeal of a money judgment, if the petitioner is indigent and can't afford a bond, that may be a circumstance indicating that there's no adequate remedy at law. So first procedural requirement, you've got to plead that there is no adequate remedy at law, and you need writ review for that reason. The second element that we mentioned is irreparable harm. Now, as I mentioned, irreparable harm frequently blends with no adequate remedy at law. It too often involves a showing that the appeal can't adequately correct the harm to the petitioner. As an example, irreparable harm may exist if the trial court's ruling is clearly wrong, meaning that it's going to be reversed on appeal. And if it's reversed, there are going to have to be two trials. The trial that would occur in the presence of the ruling that you're challenging, and then the trial that would have to occur after the appeal in which that ruling is set aside. That's the kind of thing that we're talking about, irreparable harm. Another instance would be if you're seeking review of a discovery ruling. Generally, discovery is not reviewed on a writ, but if it requires the disclosure of privileged information and it's clearly wrong, that's probably a showing of irreparable harm. Those kinds of things. There's a couple of other basic prerequisites I want to mention. First of all, the grounds for relief that you're using to challenge the trial court's ruling must have been raised in the trial court at the time, or they're going to be deemed forfeited. And the second thing you need to know is the issue has to be ripe. It has to be of immediate necessity and not have become moot by the occurrence of later circumstances. And this will tailor in also to the time frame within which you have to file or should file your writ petition. But generally be aware that you're going to have to show no adequate remedy at law, irreparable harm. You're going to have to raise the same issues you raised in the trial court, and the issue is going to have to be ripe as of the time of your writ petition. Okay, how do you commence a writ proceeding? A writ proceeding is commenced by the filing of a petition for writ relief, and that petition has to be verified. You also have to file a memorandum of points and authorities in support of the petition. And very importantly, and Andrea is going to talk about this later, you've got to file an adequate record for review. Generally speaking, what does the petition contain? The petition should contain your factual allegations explaining the procedural and factual history of the case and how the trial court erred. Factual allegations describing why there's no adequate remedy at law and why there will be irreparable harm, and a prayer that specifies the writ relief. You want a writ of mandate to order the trial court to set aside its prior ruling and enter a new order granting your motion or denying the motion, whatever it may be. Providing an adequate record, very briefly, the record has to include all relevant documents submitted in the trial court and a reporter's transcript of the hearing. Now, obviously, in today's world, at law and motion hearings, there sometimes is not a reporter. If there is not a reporter, or if any other document that was submitted to the trial court is not available, you have to explain that by declaration. And we've cited the rules of court here in this slide, as well as in our written materials, to the subdivisions of the rules that provide for what you have to say in these particular declarations. The reason this is important is, and I've quoted on the slide, that the rule states that if the petition does not include the required record or explanations, or does not present facts sufficient to excuse the failure to submit them, the court may summarily deny the stay request, the petition, or both. So very important that you present an adequate record, and I'll leave it to Andrea to amplify that a little bit in her presentation. Finally, memorandum of points and authorities. It's basically like any other memorandum of points and authorities you would file in any other law and motion matter, but it's got to be tailored to demonstrate how the trial court erred, and importantly, why relief is necessary, meaning that there's no adequate remedy at law and that irreparable harm is going to result. Stay requests. I know I'm moving fast here. The written materials will cover this in more detail, but we have a lot to cover. There is no automatic stay of a ruling pending writ review. And so if you want to stay, freeze things at status quo, generally speaking, you need to ask for a stay from the trial court first. And if you don't get a stay from the trial court, then you can ask the appellate court for a stay in conjunction with your petition. There are specific requirements, formal requirements, when you make a request for a stay. I've cited here on the slide a couple of them. Andrea's going to talk about them again, but you've got to prominently display on the cover that you're requesting a stay, and you have to identify the nature and date of the proceedings or act that you're seeking to have stayed. And in your petition itself, you have to explain the urgency, why you need a stay. Very important, because as Andy will explain, it's important for how these writs get evaluated in practice. Let me talk about some filing deadlines. I mentioned common law writs. Absent a statutory deadline, which applies to statutory writs, a common law writ petition should be filed no later than 60 days after service of notice of the challenged order. Now, this is a court-made rule. It is discretionary, but it's by and large, it is followed. So if the petition is filed 60 days after service of notice of entry of the order, generally speaking, it's going to be denied as untimely. I want to emphasize that it doesn't necessarily mean you have 60 days to file the writ. You should file it as early as practically possible, because it is possible that it could be filed within this 60-day period and yet be deemed untimely if, for instance, circumstances have changed. As I mentioned earlier, the issue is no longer ripe, or if by delaying the other side has been prejudiced in some form or fashion. The trial date is immediately upon us, and there's really not much that can be done to grant relief. So it's important to understand that for common law writs, file your petition as soon as reasonably practicable, but in no instance later than 60 days following service of notice of entry of the order. Very important for statutory writs here are the filing deadlines. As I mentioned, the filing deadlines for statutory writs are much shorter. They're deemed jurisdictional. For some rulings, such as a motion to disqualify a judge or ruling on a motion to expunge lis pendens, statutory writ review is the only method of review. Now, the language of the statutes generally uses two formulations to state when the time period begins. It's either within service of notice of entry of the order or notice of the order. I want to explain that despite this variance in statutory language, courts have interpreted the terms to mean that the statutory writ deadline commences upon service of notice, service not only of formal notice of entry, but also by the mere mailing by the clerk of a minute order containing the ruling. So be very careful. If you get a copy of the minute order that contains the ruling from the clerk by mail, the time frame for this statutory writ has started, and you really need to think about complying with that because it's jurisdictional. Just as an example, some of the time frames, so you get a flavor of what happens, what the deadlines are. Common statutory writ is a petition for peremptory writ, usually it's mandate, for denial of summary judgment or a grant or denial of summary adjudication. General rule, you got to file your petition within 20 days after notice of the ruling, and that can be by the clerk's mailing of a minute order, despite the particular statutory language. It can be extended under the statute briefly, but general rule, 20 days. Ruling on a motion to disqualify a judge, either granting a challenge or denying a challenge, it's reviewable only by writ of mandate. And you've got to file your petition, with certain exceptions, within 10 days after notice of the order. Another common writ is a ruling on a motion for a good faith settlement, either granting or denying. It's reviewable by writ of mandate, but you got to file your petition within 20 days after notice of the written order. So as you can see, these timeframes are quite short. Again, we've listed, got a pretty helpful list of some of these statutory writs and the timeframes in our written materials, and I would advise you to take a look at that when you're looking at whether your petition is going to be timely and how to get it in. Very briefly, preliminary opposition to a petition. It is possible, once a petition is filed, for the real party in interest to file an opposition prior to the appellate court taking any action on the writ. Generally speaking, it's not necessary. If the court wants a preliminary opposition, it will generally request it. But if you elect to file an opposition, you have to do it within 10 days after the filing of the petition, unless the court were to specify otherwise. I would say, tactically speaking, for the real party in interest, it's not necessary to file a preliminary opposition unless the court asks for it, unless, in this circumstance, unless when you get the petition, you see that it really misstates the procedures, procedural history, factual history, misstates the law. In that kind of instance, it's probably useful to file a preliminary opposition, but it's never required unless the court asks for it. If the court issues an order to show cause, which my colleague Judge Goodman will mention briefly, I just want to mention here to round out the procedural context. If there's an order to show cause, the real party in interest will be ordered to file a response, which is called a return to the order to show cause, and then the petitioner will get a chance to file a reply. Then the case will be set for oral argument and decision. And the order to show cause will specify when these pleadings are due. Final writ I want to mention is supersedious. This is, technically speaking, not an extraordinary writ. It's called an auxiliary writ, meaning that it is auxiliary to an appeal, and it preserves the status quo while an appeal is pending. So if there is an appeal, you file a notice of appeal for your client, and something could happen unless you get a stay pending appeal. This is when you're going to petition for writ of supersedious. And briefly, I know Andy's going to talk about this too, but I just want to mention the things you need to show in your petition. First of all, because it's an auxiliary to appeal, you have to show that a notice of appeal was filed. Secondly, you've got to show that you sought and were denied a stay of the judgment or the order you're appealing from in the trial court. Third, you have to show that absence a writ of supersedious, kind of like you have to show for extraordinary writs, the appellant's going to suffer irreparable harm if there's no stay of the appellate proceedings, meaning that the appellant's going to lose the benefits of the appeal if he were to prevail on the appeal and there's no stay. And finally, you have to show that the appeal raises substantial questions, which means, in essence, you have to show your cards. What are your grounds for relief? And you have to make a prima facie showing that they have merit. Not that you're necessarily going to prevail, but a prima facie showing. Okay, I want to make sure I leave time for my colleagues. I'm going to turn this now over to my colleague, Judge Goodman, for him to tell you about how the trial court works and some of the orders you're going to see.
Okay, thank you very much. This is Willhite. So we're going to discuss what happens, as he just indicated, in the trial court following a ruling on one of these motions before trial. In most cases, as you know, that's nothing. The ruling's made, the prevailing party gives notice, written orders prepared, case proceeds, but that's not what we're here for today. So we're discussing what happens when the party that didn't prevail decides to seek review in the Court of Appeal, and in legal speak, as we all know, that's to take a writ. Sometimes the lawyer will go back to his or her office and begin drafting that writ petition that very evening. I'm getting a little feedback on my, and I hope everybody can hear me. In most circumstances, the first time the trial judge knows that the ruling has been the subject of a writ is when the trial judge gets a copy of the petition. But as indicated on this slide, the trial judge's response is or should be silence, or at most non-evaluative and certainly not combative. Lawyers shouldn't be worried that the trial judge is going to be offended by the fact that the ruling's been the subject of a writ. As judges, we were all trained to and obliged to maintain our impartiality. This non-evaluative demeanor is indicated at the top of this slide, and we learned all that as litigators as well. You'll know, or notice rather, that in the materials that our esteemed research attorney colleague has prepared, which are in the materials, there's a list of the orders that are often challenged, and Justice Willhite has mentioned several of them already. So let's take a look at slide 22 in a little more detail. First of all, we can go back to 22. There we go. The judge has made the best call he or she can, and that's really all the trial judge gets to do. The judge has no standing to file a response to the writ petition. There's an old case which is cited here where a judge contacted somebody on the appellate panel. That is definitely what in legal speak is a no-no. That is not permitted. And the judge also, as Justice Willhite mentioned, is not a participant in the writ review. The court is just a nominal party. There's an interesting kind of conflict in the last bullet point. The government code section that cited does have an opening for the trial judge to make some kind of response to a petition, but that is definitely not the case in practice, and there's a Code of Judicial Ethics canon that specifically prohibits it. There's one instance when the Superior Court might want to give its 2 cents worth on something that's pending in the Court of Appeal that typically is a subject of concern to the trial court when there's something of institutional perspective that needs to be pointed out. But that's very rare. When that happens, there's a lawyer for the court who will do that. That is not the trial judge. So let's proceed to look at some of these. Thank you. Some of these responses from the Court of Appeal. So the appellant has filed the petition for writ. The courts reviewed it. Court of Appeals reviewed it. And then they've done the ignominious thing of, in essence, telling the lawyer who stayed up all night to get that writ petition before the Court of Appeal, this kind of one-sentence denial, the summary denial. The petition for writ of mandate is denied for failure to state entitlement to extraordinary relief. There are all sorts of reasons why this can be the case. And some of them, I think, are mentioned in our materials. But it happens, as Justice Willhite pointed out, about almost 90% of the time. There are other reasons that may come into that 90%. Let's take a look at slide 24. The next thing, and I don't know, hopefully many of you on the call know about Palma notices. It's the name comes from a case, Palma versus U.S. Industrial. What it does, the Palma notice does, it indicate that the trial judge has made a mistake, has erred in a way the appellate court considers so obvious that there's immediate relief that ought to be needed. I hope you can read the slide. In the second sentence or the second paragraph of the Palma notice that is being displayed, the Court of Appeal is clear. The responding court was required on the facts presented to, for example, in this case, overrule the demur to the amended complaint, which was the subject of the proceeding. And the court doesn't mince words. It writes in the third paragraph, quote, in view of the clear legal error apparent, close quote. And then it goes on to state its intention to issue a peremptory writ in the first instance, which would compel the trial court to vacate its order sustaining the demur and then to issue a new and different order overruling the demur. And similar things happen with respect to other matters that go up on writs. But it does give the judge a way out. It says to the trial judge, you can vacate the prior order and issue a new order overruling the demur. Now, that's typical of these notices. So let's focus on what the trial judge has to do. You will see in the bold face in this slide, there's a citation to Brown et al. Versus Superior Court. What that case held was that the trial court has to hold a hearing before it acts. So the clerk in the department is going to send a notice to the lawyers of a date on which they need to appear, maybe virtually, that's fine too, usually, and to have this hearing. So the trial court sets the hearing, and then at the hearing, what happens first is there'll be a recitation of what the Court of Appeal did, and then the judge will ask the lawyers to address that, and then the judge will make a ruling. And you might think that the only thing the judge can do is reverse course. Actually, that is not the case. It may be appropriate in every case, but there are instances, and we'll talk about a few of them in a few minutes, at least one of them, where that doesn't happen. For example, if there is an appellate, a published appellate decision from another district, which might be the reason the trial judge ruled the way he or she did, then the trial judge may decline to reverse the ruling. It also may be the trial judge thinks the issue is just not as clear as is suggested by the Palma notice. If that happens, then the trial judge will decline respectfully to change the ruling, and then provided also in the order, the real party in interest will end up filing a response to the petition. The Court of Appeal will issue its opinion, most times without argument, sometimes with argument. But in the interim, depending upon the nature of what is the subject of the writ, the case could end up in limbo. Let's go to slide 25, please. Slide 25 is an example of what happened when the trial judge declined the Court of Appeal's suggestion of a Palma notice. In this case, the trial judge thought she didn't have the authority under the discovery statutes to grant the request which the defense had made. They had begun the deposition of the plaintiff in that case. If I recall correctly, it was an asbestos case. In any event, the plaintiff himself had been diagnosed with terminal cancer, and there was a good chance he was not going to survive until the trial. So because the trial judge considered the statute to be ambiguous, she thought she lacked the authority to grant the defense the additional time it wanted to further depose the plaintiff, since he might be absent from the trial. So the trial judge did hold a hearing that was required by the Palma notice and by Brown versus Superior Court. At that hearing, she expressed her own view that the statute was ambiguous and that, again, she thought she didn't have authority. And so she declined to change her ruling. So what happened was the matter was then briefed and argued in the Court of Appeal. And what's interesting about the Court of Appeal's decision is how gentle they were, and appropriately so, to the trial judge, because she had a legitimate concern. And you'll see here on the screen how they phrased it. So this order reads in part that the petition for writ of mandate is granted, and it orders the issuance of peremptory writ, directing the trial court to do these. There's 3 or 4 things here. Either vacate its order of the specific date, denying the motion for additional time to depose the plaintiff, and reconsider its decision. But what they put it in really interesting terms. Item 2 is to reconsider and enter a new order on defendant's motion on such terms as the court, in its discretion, finds appropriate, then taking into consideration the things that are listed. What was also interesting, and what you'll sometimes see because of the nature of the controversy, as they did in this case, the court made its order final immediately upon filing of this opinion. In addition to the last sentence of the order, which was evident given the very poor health status of the plaintiff, there's a footnote in which it sounds like an apology, but you can judge for yourself. Footnote 9 says, "We did not intend, by the language of our Palma notice of December 27, 2013, to suggest that the trial court was required to grant the defendant's motion, but rather to recognize that it did have the discretionary authority to do so, and to authorize it to make a new ruling on the motion based on its exercise of such discretion." So this case is a good example of how the trial judge can respond to a Palma notice. It's not always the case that the Palma notice brings a reversal in the first instance. On the other hand, if the trial court takes the action the Court of Appeal is suggesting, could you put up slide 27, please? Then I think this is the one that says, well, we'll come back to this in a second. I'm a little out of order here for some reason. Let's go to the suggested Palma notice, after which we'll see this, the order I was referring to. So in a suggested Palma notice, as the name suggests, what it does is give notice to the trial court that the Court of Appeal is considering issuing a peremptory writ. The notice begins with some factual procedural background, and then rather than stating that the court finds clear legal error and intends to issue a new order reversing the trial court, it uses the language in this document. What it does by this is to signal the trial court that the trial court has made an error, which in most cases should have been obvious. And that's why this notice is more direct in this case than some other suggested Palma notices. So again, the question is, what goes on in the trial court? Must the trial judge reverse the ruling? Well, it depends. As with the certainty case example that we talked about a few minutes ago, the trial court has options. One of those options is not to not hold a hearing. 3 negatives there. The point is, the trial court has to hold a hearing, just like it had to with the coercive Palma notice. Again, that's the Brown versus Superior Court case. So if the trial court reverses its ruling, the Court of Appeal will deny the petition. This is the next slide, I believe. There it is. And it's very simple. The Court of Appeal just denies the discharge petition, rather, as moot. Okay. The fourth example is the order show cause. Thank you. This is slide 28. In this scenario of writ orders, the Court of Appeal issues an order show cause, and this is done when the Court of Appeal considers the issue presented one that requires a written opinion to give the trial court direction on how to proceed, or the appellate court sees the need to address an important issue of law. the OSC directs the real party of interest to file its brief. It's called a return, as Justice Willhite noted, by a date certain. After that, the petitioner will be given a date for the reply brief to be filed. Then in almost every case, there will be an oral argument filed by the appellate opinion. In the interim, the trial court suspends proceedings. I'm going to use an example, a case of People ex rel Ventura versus Superior Court. In this case, originally, when the trial judge made his ruling, the losing party filed a writ petition. The Court of Appeal denied the petition for writ of mandate. The party then sought review in the state Supreme Court, which thought the Court of Appeal had made a mistake and sent the petition back to the Court of Appeal for review of the petition on its merits, which happened in Division 5 in the 2nd District. And it then heard argument and granted the petition, and it gave the trial court specific instructions on how to proceed, which the trial judge followed to the letter. Trial judge did exactly what the Court of Appeal ordered, vacated the prior ruling, proceeded to rule on the people's motion in accordance with the analysis and the opinion of the Court of Appeal on the legal issue on which the trial judge had originally ruled incorrectly. Some of you may be thinking, well, how do trial judges view all of this when they get reversed all the time? And the Supreme Court even tells the Court of Appeal that it made a mistake first time through. But if there's any thought that a trial judge feels badly about these things or loses credibility or stature by being reversed, that is just not the case. For example, in this particular case, in People ex rel Ventura versus Superior Court, the trial judge, who had erred significantly, he had ruled contrary to a prior California Supreme Court case, is now sitting on as a permanent justice on the Court of Appeal for the 2nd Appellate District. The 5th example is the alternative writ that you see on your screen now. This is an option to the Palma notice. It literally presents alternatives, perhaps in a less dramatic fashion than the Palma notice. But this is an example of the text that gets the attention of the trial judge whose ruling is subject to the order. This option is used by contrast to the suggested Palma notice when the error is less obvious, but can be explained in a brief error. Do I have 5 more minutes, Justice Willhite? I don't know. Probably not. So I will save that vignette in case it comes up an answer to a question. One final procedural note is that the opinion is not the writ. The writ's issued separately once the opinion is final. Thus, the trial judge and the lawyers have to wait until the writ's issued to resume proceedings. But that's when everything happens again in the trial court on the particular issue. And with that, I'll turn it over to our esteemed appellate writs attorney, who's probably seen more writs than any 3 of us combined.
Andy, you need to unmute yourself.
Hello. Hi, my name is Andrea Ventura. I'm a writ attorney for the Division 4 of the 2nd Appellate District. Now, I'm going to walk you through the process of when a writ comes into the clerk's office and then gets to the writ attorneys and what happens. This is all from the perception of the 2nd Appellate District. Different districts might have different procedures, and each division may have their own particular process by which the writs are reviewed. So, but there's some generalities that apply across the board, and I will try to encompass them. So writ petitions, once they come into the clerk's office, once they're filed, are assigned randomly to a specific division of the Court of Appeal. Here we have 8 different divisions in the 2nd Appellate District. There are some exceptions to that. And so if a petition that is filed has already is a case in which a division had already handled an appeal or a prior writ petition, then that writ petition will be assigned to that same division. It's basically institutional knowledge. And there's maybe on a more global front, although this doesn't happen often, sometimes a particular division will have been reviewing a particular type of cases, such as coordinated asbestos cases. Therefore, a new writ petition that comes in addressing that issue will be assigned to that particular division based on institutional knowledge. So once a writ petition is assigned, it will go to a division. In the Second Appellate District, each division has 2 writ attorneys, and they divide up their writ petitions. And then once you get the writ petition as a writ attorney, I analyze the writ petition and draft a memorandum, or maybe create an oral presentation, providing a recommendation of what to do with this writ petition and a proposed order for consideration. And then we present that to a panel of 3 justices, 3 appellate justices. Different divisions have different schedules for writ conferences, which the justices get together and they review these writ petitions and the memorandum and proposed orders. Sometimes it's once a week, sometimes it's biweekly, sometimes it's monthly. It depends on the division. So as you've seen by Justice Willhite and Judge Goodman, there are some key issues that we evaluate when we look at a writ petition. First and foremost is what trial court order is being challenged. And as Justice Willhite mentioned, that's predominantly because of if it's a statutory writ or a common law writ. Sometimes if it's a judicial peremptory challenge below in the underlying court, then I know there's a 10-day window that a writ petition has to be filed. We also look at how an appellate decision will impact that order. Sometimes, as Justice Willhite said, 90% of all writs are denied because we have to wait for the appeal, which is a long, thoughtful process to review a trial court, a supposed alleged trial court error. Then we look at the nature of the underlying lawsuit. Often that's for the premise of understanding irreparable harm and whether there's a stay required. A lot of dependency cases tend to have stuff that's more subject to a temporary stay and is in need of immediate appellate review. And on that note, one of the main things I look for is there a request for a stay? So if we can go to slide 31. Sorry, I'm not doing the slides. Can somebody else?
It's frozen here, I'm sorry.
There we go.
There we go. So temporary stays, they're very, very important to follow the rules. California Rules of Court 8.116 and 8.486A7 are the key rules that govern temporary stays. You must comply with these rules or else, as Justice Willhite mentioned, it gives us authority to deny the stay and even arguably the petition. Most lawyers are good about asking for a stay requested, putting those words prominently on the cover of their writ petition. But what is key is that you also include the nature and the date of the proceeding or act that you want to be stayed. That governs my life. If there's a stay request comes in and it's for a stay of a hearing the very next day, and it's a hearing for dependency that they're going to take the child away, then I'm going to put everything else aside. As a writ attorney, that's my job. I have to put everything else aside and focus on this issue if these things are on the cover of the writ petition. And then I know that I have to focus on this. So that's key. You guys, please remember that. Also on the cover or at the beginning of the text, you must state the court that you're in, the department involved, and the name and telephone number of the trial judge. Okay, we'll go to the next. And as we've said, this is, I'll just reiterate why following these rules is really important. As Justice Willhite mentioned, if you do not put these this information on the writ cover, we have the ability to decline the request for a temporary stay, both in a request for a temporary stay as well as a request for supersedious. Because once we get it, we assess whether a stay is warranted. And then we have to track down 3 busy appellate justices who are dealing with their appeals. And we have to ask them to agree or disagree with the recommendation to issue a stay. And half the time we have to write a memo while doing that. So therefore, the earlier a stay request is filed with all the requisite information, the better the chance the attorney or the party will secure a stay if it is warranted. So please, please, please don't file your writ petition requesting a stay at 4:30 p.m. Seeking to stay a hearing or act the very next day. Oftentimes, at least here in the Second Appellate District, our clerks have shut down at 4:30 p.m. So oftentimes, if you file something after 4:30 p.m., we won't get it as a writ attorney till the next day, or even sometimes administratively won't get it for a day thereafter. Please don't file a frivolous stay request just to try to buy some time for your trial court. There may be some divisions that will grant a stay upon request. Division 4 does not. We have to analyze each and every stay to see if it's warranted before we grant it. And so if you are violating or abusing this process, some research attorneys, not myself, but some research attorneys keep lists of attorneys and parties that abuse this process, and we'll look at that the next time a request comes around. Okay, the next slide. As for supersedious, again, follow the rules closely. California Rule of Court 8.112 governs petitions for writ of supersedious. Specifically there, the caption format is exactly the same as the appeal. It's the title bears the same title and the same docket number. So it's a little different than a normal writ petition. And a writ of supersedious will likely be denied without prejudice if the appellant did not ask the lower court for a discretionary stay. And if it will be granted, we still, by rule, we have to wait 15 days after the petitioner has filed or the appellant has filed their writ for supersedious, giving the opposition a chance to oppose their request. So on that note, once a writ attorney gets their hands on a writ, the procedural evaluation is, I think, the first round of review. And those main issues as have been raised as timeliness, adequate record, verification, and service. If generally speaking, if any one of these issues is not complied with, then the panel has the authority to deny a writ and most likely will. Verification must encompass the petitioner's allegations and authenticity and accuracy of the supporting exhibits. Verification on information and belief is insufficient. Please serve the petition in one set of supporting documents on the real party and interest. You do not need to do the supporting documents with the respondent court. And the record is really, really important. If we don't have an adequate record, we can't analyze whether the trial court erred. So it's pretty clear, like if you don't give us all of the documents that the trial court reviewed in order to make its decision, we can't reverse them. We can't issue an alternative writ. We can't issue a PALMA notice. So it's pretty key. And there is a rule stating that we have authority to deny on that basis. So unless you have an adequate record, or as Justice Willhite mentioned, giving us a declaration why the record is not available and the urgency for such a review, we will deny the writ summarily. And then also, not as prominent, but you do need to serve the Attorney General at times, depending on the underlying nature of the lawsuit, such as Business and Professions Code Section 17209 for unfair competition, as well as antitrust actions, because the Attorney General may weigh in on those issues. So if you make it through all 3 of those procedural hurdles, and there are others, but those are the main 3, then we as writ attorneys look at the merits of your writ petition. So as Justice Willhite pointed out, you have to you have to give us the factual and procedural background for what happened in the trial court. And that's key. But at the same time, also, please do not focus on the error of the trial court all the way, because the less emphasis you put on justifying why immediate appellate intervention is warranted, the less strength your petition will have. We need to know why there's the appellate intervention is needed, and why extraordinary relief is required. So please focus on that. Also, don't avoid negative case law or authority. Sometimes there might be cases that suggest a writ review is unlikely or unfavorable, but there may be other issues in your writ, such as this is a novel question of law, that does support writ review. So please don't avoid that negative case law. When you do that, then it takes us as writ attorneys, our research, sometimes we already know that there's case law that's against you, and then you become less credible, and we find all the strength to show why this writ should be denied. So just address it and walk through it. And as has been mentioned throughout, a case that I highly recommend each and every one of you look at before you file any writ is Omaha Indemnity versus Superior Court. I'll do the pin site right now, 209 Cal App 3D 1266. That's a great case for understanding what makes or breaks an appellate writ petition.
Well, thank you, Andy. Thank you, Alan. We've finished our presentation. I think we may have time for a couple of questions. I just want to reiterate, I know we've covered a lot of information today, necessarily so in a short period of time. Please refer to the written materials and citations that we've given you. Final word, appellate writ practice does require careful adherence to the formats and procedures, and it can be a fatal trap for the unwary. And therefore, please take our advice into account, and also what we've presented to you in the written materials, because they will provide further guidance. And, we hope that with attention to the stuff that we've presented, you can maximize your chance for obtaining relief. Katie, do we have any questions we can answer here?
We have 9 questions in the Q&A.
Oh, yes.
We do. Thank you all very much. Just a note to all of the attendees, we're just about at time, but our panelists are graciously willing to answer a few questions. You're welcome to stick around for that. If you do need to hop off to get back to work, you still will receive the full hour of credit. I will post the link to the handout materials in the chat once more. When you do leave the webinar, you'll be directed to a brief survey. We would really appreciate if you take a couple of minutes to fill that out. Let us know how we did and any thoughts for future programs. In the questions, we have a number of questions going on here. How does a motion for reconsideration affect the timeliness of a common law writ, if at all?
It doesn't, right, Andy?
Right. When we get a writ that oftentimes we will get writs that address the underlying trial court issue and then the reconsideration. Reconsiderations are not addressed on writ review. So we usually deny those pretty much out front, depending on, there may be some solid issues on the underlying trial court act. If it was a discovery motion that deals with privilege, arguably we might not address, we might let it move depending on the issues. But yeah, yes, Jen.
Mm-hmm. And does the petition need to be served on the respondent court before filing, or can it be served after filing?
Well, it's served at the same time that it's filed, and so the proof of service should have the proof of service on the real party in interest as well as the court. So it'll be served at the same time.
Now, here's an interesting one. The first district seemingly issues far fewer writs in civil cases than the other districts. Why is that? And are there any tactics to get first district review that you could comment on?
Yeah, I really can't speak specifically to the first district and why they don't, at least in your experience, they've been less likely to issue writ relief. I would say that it's very necessary to always demonstrate why you need immediate review, whether it's, it's the inadequate remedy at law and irreparable harm. But I don't know. I really wouldn't have any advice for a strategy as to why they tend to issue fewer writs than other districts. I'm sorry.
One big one we have, kind of speaking to the real why of the appellate writs. If 90% are denied, why would you even advise your client to spend the money and time going through the process?
Well, it's true that 90% are denied, but the 10% that are not are the ones that are very important. They are urgent. They're going to give your client relief. As an example, discovery orders generally aren't reviewed, but as I mentioned, if it's going to require you to produce privileged information to the other side and the trial court is wrong, that's important. If a demur was sustained without leave to amend to a particular cause of action, and it's wrong, and that cause of action implicates or addresses concerns that aren't going to be addressed in a trial on the other remaining causes of action, that's something that's important, and your client needs it. So in saying that 90% are denied, that's just a reality check for you to do the due diligence to decide whether or not this is something you want to do. But for those cases in which writ review is granted, it's granted because it's important in the case. And irreparable harm to the client is going to occur unless there is writ review. So that's why you would require the time and expense in the appropriate case.
Interesting. We do have a few more questions here. A procedural one: 20 days after service, is this date of the order or date of the receipt of the order?
This date of service.
Date of service. Thank you. And do trial judges read the writ petition served on them, given that they cannot respond to it and it should not affect their impartiality?
Allan?
It depends on the trial judge. I read most. Occasionally you think this is never going to be granted or there's a procedural problem, so you stop reading at that point. But I read most of them. And that's the only answer I really can give. There are judges who don't read them. There are judges who read every one.
I think generally they're read. I mean, I used to read them all just to get a handle on it. Generally so, yeah. Even though you can't respond, you can't do anything.
Yeah.
Another couple questions. Is it appropriate to seek a writ for a denial of a demur or to seek an appeal of the demur order?
Andy?
Is it appropriate to seek a writ for the denial of a demur? If it's without prejudice, no. Or without leave to amend. But it's so basically you'd be overruling a demur. Is that what the question is? It depends. Usually the general rule is not to address, we do not address writ review at the pleading stage. So it depends on the particular issue. And so I would have to look back, and it depends on the circumstances in the case. It's hard.
Yeah, my answer would be generally you're not going to get writ review on the overruling of a demur unless one of the situations I mentioned, maybe it's an important issue of constitutional law that needs to be settled. Maybe it's clear on the face of the complaint. Or maybe the trial court has relied on an interpretation of the law as to which there's a conflict in the trial court, and the appellate court wants to address it at that stage. But it's fairly unusual. But those are circumstances in which you could get review on the overruling of a demur, but generally not.
And here's another one. Since Brown in 2010, in cases where a suggestive Palma notice is issued, is there any data on the percentage of cases where the trial court, as suggested, promptly reversed the ruling being challenged? After Brown, some were concerned this would be the outcome of many cases, effectively resolving hotly contested issues without thorough appellate review.
I don't think there are no statistics, and I would ask Allan to weigh in on this. My experience is, however, that most of the time the trial court changes its ruling. I would note that when the trial court changes its ruling, it doesn't mean that the issue isn't going to get review. Generally speaking, it'll be reviewed following an appeal, but it won't be reviewed by virtue of the writ. So I don't know statistics, but I think, at least in my experience, generally speaking, the trial court does tend to change its ruling unless it feels strongly that it was right. Allan?
Right. Well, I agree with that statement, particularly the last part of it. I can think of a case where I declined to change my ruling on a matter. The case actually went to the state Supreme Court, which issued an opinion which confirmed that I was wrong, except that 2 years later, there was a change in the statute because the issue actually was quite significant, and there was good reason to make the change. So I don't, there's a negative inference here that trial judges automatically change their rulings. And I think in most cases, the trial judge is going to make a considered reconsideration and then decide whether she or he is going to change and do what the Court of Appeals suggests. Sometimes the Court of Appeals is wrong, but never Division 4.
I haven't done a PAMA notice since I've been in Division 4, and I've been here 4 years. So.
Okay.
We are just about at the end of our extra time here. I do want to be cognizant of folks who have to get back to work for the afternoon. If you have any questions that we didn't get to, or if you have any other questions for our panelists, we do have some contact information in the handout materials. Again, we'd really appreciate if you take our quick survey when you hop off of the Zoom right now. But thank you so much to our 3 speakers today, and for your time and for your generosity with all of this information.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.